We'd like to know. That Eichmann court went further to observe that the distinguishing mark of a manifestly unlawful order should fly like a black flag above the given order as a warning reading prohibited, and it had been suggested by at least one court as a bright line rule and not mere formal illegality, hidden or half hidden, not the kind of illegality discernible only to the eyes of legal experts, but a flagrant and manifest breach of the law, certain and necessary illegality appearing on the face of the order itself, the clearly criminal character of the order or of the acts ordered, and illegality clearly visible and repulsive to the heart, provided the eye is not blind and the heart is not stony and corrupt. That is the extent of manifest illegality required to release a soldier from the duty of obedience upon him and make him criminally responsible for his acts. What do you think? We'd like to know. Courts have said in your AB sessions that when a matter shocks the moral conscience, even a defense of sovereign immunity falls away, piercing the veil. Would it take the massacre at My Lai during the Vietnam War, over 500 persons massacred, to shock the moral conscience? Would half that number be sufficient? Or about the number of deaths that have occurred due to COVID-19 in the city of Alexandria? What do you think? We'd like to know. And yet, according to Prosecutor Porter, in the city of Alexandria, he is apparently above all law, holds plenary and absolute power, and accepting, and arguendo, as a pure hypothetical, that if there was a probable cause established that the Alexandria mayor, Justin Wilson, again, just a hypothetical, had committed both murder and terrorism, no court in the land could order the Commonwealth's attorney to charge anyone, suggesting that the decision to charge a citizen is a discretionary duty which lies entirely within the province of the public prosecutor, even if the plain language of the Virginia Code states that a prosecutor shall mandatorily prosecute a felony. But do you agree? Or more probably, the question might be posed, is that true? Is that an accurate statement of the laws of the Commonwealth of Virginia that Porter has a constitutional duty to enforce? What do you think? We'd like to know. According to Prosecutor Brian Porter, in an assertion essentially of the doctrine of sovereign immunity as applied to the international law, no person has a right to order any prosecutor to prosecute any war crimes or even crimes against humanity. And it is entirely the decision of that prosecutor, be it the death of just one or even 1 million or more, which may come as a disappointment to the Arlington NAACP because they want the Attorney General to investigate, as has been actually requested in this particular application, asking not to arrest or prosecute anyone, just simply to investigate. But Attorney Porter says no, he does not even have to deign to do that if he does not want to. Right there in the city of Alexandria. The choice rests solely with the prosecutor, according to Brian Porter. And in 2021, Prosecutor Porter had been elected by 97% of the voters in the city of Alexandria, while running unopposed, not even challenged by any Republican. And it was his opinion, as the infallible prosecutor, that was unequivocal proof in evidence that he had to have been doing something right. Do you agree? More properly, the question might be posed, is that true? What do you think? We'd like to know. At least according to the laws enforced by the federal judiciary or Article 3 courts, quite contrary to Prosecutor Porter's argument regarding an assumed plenary authority, mere acquiescence or silence or failure of an officer to perform a duty does not make one a participant in a conspiracy unless legally he acts or fails to act with knowledge of the purpose of the conspiracy. Does he have knowledge of the conspiracy? Does he have a purpose of aiding and abetting it? Because, at least, as stated in the criminal matter, Lutheran v. U.S. decided it by the 8th Circuit in 1937, quoting Burkhardt v. U.S., decided by the 6th Circuit in 1926. If he does so with the view of protecting and aiding that conspiracy, he is guilty of participation in the conspiracy. In the legal sense, what do you think? We'd like to know. According to Commonwealth Attorney Porter, the petitioner has no clear right to relief, and there is no legal duty on the part of the respondent to perform the act which the petitioner seeks to compel. And yet federal courts, where the application is now going, have suggested that individuals who act entirely independently of the foreign terrorist organization to advance its goals or objectives shall not be considered to be working under the foreign terrorist organization's direction and control, as announced by the U.S. Supreme Court in 2010. However, in the matter Holder v. Humanitarian Law Project, a terrorist is anyone who attempts to further his views by a system of coercive intimidation, as stated by the 7th Circuit in 2009 in the criminal matter U.S. v. Christensen. What do you think? We'd like to know. Moreover, as announced in U.S. v. Heard, a bribery case decided by the 5th Circuit in 2013, a topic which is very timely now, is Senator Bobby Menendez up in New Jersey, has been indicted for bribery because a prosecutor decided, perhaps because he felt like it, that Senator Menendez should be charged. A defendant is presumed to continue his involvement in a conspiracy unless he makes a substantial affirmative actions of withdrawal, abandonment, or defeat of the conspiratorial purpose. Mere cessation of activity in furtherance of that conspiracy is not sufficient to show withdrawal. What do you think? We'd like to know. And clearly, by advancing such arguments under penalty of sanction to the court in which he has refused to even appear to make these arguments personally for himself, Commonwealth Attorney Brian Layla Porter may not be doing something right this time, and fatally fails to satisfy these disavowal requirements. And Federal Rule of Criminal Procedure 6A, which shall apply in the federal courts to which we are bringing this application, states that when the public interest so requires, the court must order that one or more grand juries be summoned. What do you think? We'd like to know. My name is Major Mike Webb. By God, I am running for state legislature with liberty, excellence, and honor. Honest. This message was approved by Major Mike Webb. Honest.